Thank you all for joining us today. We're very excited to have you here. And before we turn it over to Paul Smith and Danielle Lang from CLC, Casey and I are going to tell you a little bit about what we have going on in the voting rights space at ACS and how you all can get involved. So I'm going to turn it over to Casey first to talk about our Constitution in the Classroom program and our voting rights curriculum for that this year.
Sure. So if you all don't know, ACS has a pretty robust Constitution in the Classroom program, which I help coordinate along with my boss, Ashley Erickson. What the program basically is we get lawyers and law students to go into their local schools, whether it's elementary, middle, or high school, and teach curriculum that we've presented. For this calendar year, we're doing voting rights. For the previous school year, we've had lawyers and law students engage over 20,000 students. And we make it really easy. We provide the curriculum online along with worksheets and PowerPoints and other resources. And some people want to kind of just use our curriculum, but we encourage everyone to present regardless of kind of what topic about the Constitution you want to present about. It's a guideline, but we think voting rights is particularly salient in this time, as I hope our panel will discuss more. And then, should I talk?
Yeah, go ahead.
Sure. Okay. The flyer that you've received at the door has a link to sign up and to learn more about our program, including taking a look at our curriculum and our previous year's curriculum. And we're really excited to keep growing this year. So we have our major pushes around Constitution Day, which is September 17th in the fall, and then also Law Day, which is May 1st in the spring. But we're free to work with anyone's schedule, and we're happy to coordinate a classroom with you guys or help you set up a classroom yourselves. A lot of people find it useful to kind of go into either if they have small children to go into those schools, or to if they have a friend who's a teacher, sometimes they'll go teach at their classroom. But we're happy to involve yourself. Also, our local chapters have coordinated, consolidated CITC pushes often if they're in major metropolitan areas. The Bay Area has a big Constitution in the Classroom push. The DC lawyer chapter has a big Constitution in the Classroom push. And we even had Oregon do a big Constitution in the Classroom push with over 6,000 people last fall. So we're really looking forward to getting anyone involved. I'd encourage you to either talk to me after or look at the flyer and sign up, visit our website. It's a really great opportunity, and if you're excited about the Constitution or worried about the lack of civic education in our schools, we encourage you to get into the classroom. As lawyers and law students, you have a wealth of knowledge that these students don't have, and they'd love to hear from you.
And at the end of this session, we'll be breaking into working groups, and you'll have opportunities to focus on some of the areas that we're talking about, and then or join Danielle and talk more about rights restoration and what CLC has going on. So if you want to hear more about Constitution in Classroom, you can also join Casey in the second half of this session. In addition to CITC, we are also working with law students to cancel classes on Election Day at their law schools. It can be quite a process to work with your law school administration and get faculty on board, but it's an amazing opportunity for law students to use their knowledge and give back to their community surrounding their law schools. It is public service at its finest. And we've had several schools who have done this since 2016 when students at Northwestern first started. And I lead that. I'm leading this project at ACS. If you want to cancel classes on Election Day, please join the working group in this group or follow up with me after. My name is Molly Green. We didn't introduce ourselves.
Sorry, I'm Casey.
I'm Molly Green. I'm the Assistant Director of Chapters for the West Coast and for Arizona and Nevada. So I work with all of our lawyers and students out in the western part of the country. I also oversee our election cancellation project. So we are currently working with some amazing students from Denver to put together a blueprint over the summer. It should be available. But like I said, in the meantime, we can talk more about what this looks like, why it's important, and the different opportunities that you can plug into, whether it's if you're able to work as poll workers where your school is, or tap into other nonpartisan voter protection efforts. So that is one of the other projects we have going on. You want to talk about AVL?
Sure.
Perfect.
So ACS is part of our All Voting is Local campaign, which works to ensure the right and ability to vote is protected at all levels. So the campaign helps communities through education, and particularly communities of color, but we also do advocacy as well. And we just try to identify and remedy barriers to the ballot box. So in collaboration with other groups in the coalition, we're building power among those groups, and I encourage you to sign up on ACS's website. There will also be the flyer should mention visiting our website. AVL is prominent in Arizona, Florida, Ohio, Pennsylvania. They're getting started even in Wisconsin. So if you're in one of those states, consider signing up, getting involved. We'd love to have you.
All right, last project, I promise. The other thing that we are working with is that there is an organization that is based out of Los Angeles that got started this past year called the Civic Center. And this organization is focused on pre-registration for 16 and 17-year-olds where they are able to do so. They've targeted the states. They're also doing work to make sure that schools are compliant with laws that require somebody in the school to be in charge of voter registration and to make sure students are getting registered. So if you are interested in tapping more into working in high schools, working with high school students on voter pre-registration, it's an amazing way to increase voter turnout, get them while they're young, talk about the importance of voting, make a voting plan, and make sure students are registered. So that's another thing that you can reach out to either myself or Casey about. We won't be having a breakout session for that in particular this afternoon, so if it's something you're curious about, just send us an email once convention is over. And without further ado, I'm going to turn it over to our real experts this afternoon, Paul Smith and Danielle Lang from the Campaign Legal Center.
Welcome, everybody. I'm Paul Smith, and among other things, I've been extremely active in ACS since a long time ago. Been on the board for a long time until just this year. And it's always encouraging to see the huge variety of new projects that the ACS is coming up with. And of course, it's really nice to see you all here at the convention. Convention every year is such a wonderful experience in getting together and recharging the batteries and going back to the fray. I want to talk just a few minutes about one of the places I work. I also, as many of you know, some of you know, at least I teach at Georgetown Law these days, but I'm also a vice president of Campaign Legal Center, or CLC, where I work with Danielle. Mostly she does the work, and I just take credit for it. Is how it works at CLC. And what is the Campaign Legal Center? Well, we are an organization that's been around for about 17 years that works on democracy issues, often with other organizations, not alone, but certainly a central part of the array of nonprofits that are working at this moment to save American democracy. When we started, CLC was formed to defend the McCain-Feingold law back in, it was passed right at the beginning of the century, and had a very successful run at that, arguing that the First Amendment does not require complete deregulation of the campaign finance system with the McConnell case. That area of law has become more challenging in recent years in the sort of post-Citizens United era, but we have kept up the fight for sensible regulation to make the system work better. And we have basically two strategies in that area in this sort of difficult era of the Supreme Court. One is to continue to promote the things that are perfectly clearly constitutional even now, like strong disclosure laws, which we don't have, public financing of elections, things of that sort. And the other is to try to lay the groundwork for a day. Maybe it's further off than we had hoped it would be, but a day when the jurisprudence will start moving back in a better direction. We are certainly of the view that having the whole election system run with dark money and no visibility and no regulation is just insane. Nowhere else in the world does it that way. Why should we? So that was the original sort of focus of the organization. But in the last 8 or 9 years, it's become clear that there's a lot of other work to be done. And so one of the things we did is take up a role in the long effort to fight partisan gerrymandering, an issue that I worked on when I was in private practice, but now we've continued to work on, and we had the Gill versus Whitford case, the Wisconsin case that I argued in the Supreme Court last year, where for the third time I've argued this issue, the Supreme Court neither gave us a win nor a loss, just punted and sent us back down for more work to be done in Wisconsin. And we, along with a number of groups in co-counsel, have the Rucho North Carolina congressional gerrymandering case, which is pending in the Supreme Court right now. And sometime this month we'll find out, along with, there's also a Maryland case, a companion Democratic gerrymandering case, as you know, pending up there. Sometime this month we're going to find out, I think, maybe they'll punt again, but I think we'll find out whether the Supreme Court is ever going to put some limits on gerrymandering. The problem in this weird area of the law is not whether gerrymandering is unconstitutional. All 9 justices have long believed that it's unconstitutional. It pretty much has to be. It's the use of government law and power to decide in advance that one political party should win elections and another political party should lose elections because the government has decided it likes some people's views better than others. It's pretty hard to imagine a more unconstitutional thing than that. But the problem has always been, the court has said, well, we have trouble identifying where the line should be drawn. We want clear standards, so maybe it's justiciable, maybe it's not, and that's what we're going to hope to find out. The third real main area of our work, and a lot of other organizations too, of course, is voting rights, and what we've seen in the last decade or two, a rise in efforts to prevent people from voting because somebody in power doesn't think that having them vote would be very good for the outcome of the election, to try to tailor the electorate to preserve the powers that be in the face of a changing population, a population that's becoming younger, more minority, more liberal. But if you can keep those people from voting, you can have a beneficial effect on the powers that be. And so what you see is a whole variety of things that we've been taking on. And I could talk about a lot of different cases. We've litigated voter ID cases and everything. But let me just mention a few of the things that happened just in the last year. With 2018, there was a whole series of things that started to happen leading up to the midterm elections. An example was the law you probably heard about in North Dakota that required not just voter IDs, they already had that law, but required that the voter IDs have street addresses, which created a specific problem, not for everybody in North Dakota, but for people on Indian reservations, which either don't have street addresses or have been assigned street addresses that don't correspond to reality in a variety of ways. And so there was this huge problem. We went in, sought a TRO, and didn't get that, but we have that case being litigated, and I think ultimately we'll probably reach a good resolution on that issue in North Dakota. Even more recently, after the election, there was this remarkable effort in Texas to purge 95,000 newly naturalized people from the voting rolls. The Secretary of State had looked at the voting rolls, who's registered to vote, and compared them with driver's license records. And said, here are 95,000 people who said they weren't citizens when they got their driver's license, and therefore they're suspect. We think they're fake, they're non-citizens who've registered to vote, and they told each county to send out a letter saying, if you don't come in and prove you're a citizen in 30 days, we're taking you off the rolls. The problem with this was that driver's licenses last 6 years in Texas, and so hundreds of thousands of people in the last 6 years have been naturalized every year. And they have their driver's license when they're not a citizen. Now they've registered to vote. And so it was a neat way to try to purge 95,000 newly registered, probably Latino people from the voting rolls, which we succeeded in getting enjoined. Those are the kinds of trickery and horrible stuff that's going to be coming along. And my guess is that 2020 is going to make 2018 look like child's play as we get to the point where there's this really titanic fight about who's going to stay in power in 2020. So we are gearing up to try to help play a role along with others in trying to hold on to the democracy as much as we can as we head to the 2020 election. But with that overview, let me refer to another big area of our work, which is what Danielle's going to talk about today. I should say that everything I just told you about North Dakota and Texas was all work done by Danielle. And so she was off running around the Indian reservations in the last week before the election, and then she was running around Texas getting the injunction against the vote purge. Another program that Danielle helps to run at CLC is our program on felon I call it re-enfranchisement. It's a positive name. There are these felon disenfranchisement laws around the country that have been around a lot. They're closely connected with the history of Jim Crow being brought back and the restoration of white power in the South at the beginning of the 20th century. And the argument that you should be able to vote regardless of having been a felon, just flat out that these are unconstitutional is a very difficult one to make. But there are lots of ways in which you can use litigation to push back against these laws. And that's something we've been doing in Alabama for a long time. Another thing you can do, of course, is the repeal law, which they just did in Florida. And now we're having big fights down there about whether the legislature will let the vote of the people actually take effect. But we have found that there's a ton of work to be done in this area, and it involves a lot of people. There are millions of people in this country who actually think they're disenfranchised for having been a felon and aren't. And they just don't know it. And so one of the things we're trying to do is work on getting the word out that you can vote. And in addition to changing the laws in a lot of ways. And so that's a very general introduction to what I think we're going to talk about some more. The whole idea of this session is to be a workshop on involving yourselves in this work of educating people, registering people to vote, and pushing back on the laws and rules to broaden the opportunity for people to vote. Because this is a very significant part of the population with a heavy minority representation, given a lot of other social conditions in our country, of people who are denied the right to vote and probably shouldn't be, and in many ways we can help to fix that, and that's work that at CLC we've been doing. And so let me turn it over to Danielle Lang and let her start talking in greater detail about both what we're doing on felon disenfranchisement and what you all can do as well.
Thanks, Paul. And that was all very, very kind.
Every bit of it was completely true.
But we have quite a voting rights team that works with me, so I by no means can take the credit for all of that extraordinary work that we have been able to accomplish. And I want to thank ACS for having this panel and deciding to focus some time on an issue that is near and dear to my heart, and it is, beyond exciting for me to see how many of you are also interested in voting rights. I know there's a lot of really interesting stuff going on at this conference, and I'm just really appreciative to see all of these faces in the room that care about this issue in particular. So I'm going to start with a bit of an overview of the problem, which I'm sure many of you are familiar with, and just kind of layer in why we have the extent of the problem and how we got here. And then I want to spend a lot of time actually talking about the kind of myriad ways I think that people can get involved, because I think felony disenfranchisement has felt like a hopeless issue because some of the legal pathways to fighting it have been closed off, but it's actually, there's so much work that can be done in this area that will make an impact on individual lives, even if we can't overturn the case that allowed felony disenfranchisement overall. And so I want to leave us on a hopeful message. As Paul said, we're going to have, I think, some breakout time, but I also really want to encourage people, as they have questions while I'm talking, to feel free to raise your hand and go up to the mic and ask questions. I think it'll be a more interesting conversation that way. And then I am going to save time at the end if you have questions as well. Millions of Americans cannot vote, right? Why? The numbers in the most recent study that was done by the Sentencing Project, which does the best sociological research on how felony disenfranchisement functions across the states, was in 2016, and estimated that about 6.1 million Americans could not vote because of past convictions. And the vast majority of those people are not in prison. So there is a segment of that population that is actually imprisoned, but the vast majority of those individuals are people who are living in our society, paying taxes, expected to have work, support their family, but are not allowed to participate in their own political system. And that's about, now that number, luckily, is at least a little bit smaller today. Because of important movement that's going on in the states. In 2019, this legislative session, both Nevada and Colorado have enfranchised people who are on parole. So as long as you are out of prison in either of those states, you can now vote. Nevada used to be one of the most complicated and most restrictive felony disenfranchisement laws in the country. We did a lot of work in 2018 there trying to help people kind of get through this very complicated process. We were, during that campaign, able to raise a lot of awareness about the issue in Nevada, and Nevada just re-enfranchised everyone post-incarceration. And then, of course, as Paul mentioned, and I'm sure many of you are aware, there was the passage of Amendment 4 in Florida that has the possibility to enfranchise well over 1 million people. What that number is actually going to be is a big question right now, because of the passage by the House and Senate of a bill that would define who is eligible under Amendment 4 in restrictive ways. That bill hasn't been signed yet by the governor, but he has pledged to sign it. So that's coming down the pike, and there hasn't been good research yet on figuring out exactly how many people will be enfranchised under Amendment 4 because of that. But by conservative estimates, maybe that number is more like 5 million now, but that's still an enormous part of our population. The 6 million figure represents 2.5% of the total U.S. population, and these numbers won't be all that surprising, but they are enormous. The kind of racial disparities, so 1 in every 13 voting age black person in America is not able to vote. It's 1 in every 56 for whites. We still have states that have permanent disenfranchisement, even for people who have relatively minor felonies. And those states are Kentucky, Iowa, and Mississippi. And there is movement in each of those states that I think is worth paying attention to. And there are states where over 20% of the voting eligible African American population cannot vote.
It's interesting.
Absolutely.
There is a lot of political momentum to actually get rid of a lot of these laws, and it is one of the few issues in the United States right now that cross the divide between the left and the right. There's something about this issue. We saw this in Florida where they got over 70% of the vote. It resonates, I think, with conservative religious people who believe in forgiveness and redemption in a way that makes it something where real progress can be made, not just by litigation, but just by going out and campaigning.
Yeah, Americans for Prosperity is running a Second Chances campaign. So this is really a really important bipartisan issue, and it is a place where we actually have a lot of opportunity for movement. One other thing about that 5 million figure is the ways in which that kind of echoes out in the community and actually impacts a much larger group of people. So as Paul mentioned, there's millions of people who I think don't think they can vote, and I'll talk about that a little bit more later. There's best estimates are about 23 million Americans with past felony convictions. Maybe about 5 million of them can't vote. The rest of them can, but there seems to be this common knowledge that you can't, and that's obviously creating a much bigger ripple effect. That people know these laws exist, they assume that they cannot vote. And the other part of it is that there's been really interesting social science research about how the disenfranchisement of minority communities actually echoes out on the political participation of their entire communities, right? So if many members of your community cannot vote, it's actually going to affect the political participation of even those who can vote, those who are eligible to vote. And so the impact of this of these laws is really enormous on our political participation, especially among historically marginalized communities. This is a map from a report that CLC will actually be putting out later this month, but it's done, so I put it in here and get a little preview. Yeah, where we're trying to research how many states hinge the right to vote and access to rights restoration on the ability to pay fines and fees. And we've come to the conclusion that it's about 30, which is a really extraordinary number in 2019 to say that there are at least 30 states where your ability to pay off legal debt might be the reason or that you can or cannot vote. And the reason for that is that we have this broad array of ways in which you can get the right to vote back. As I mentioned, there's only a couple of states where you have permanent disenfranchisement absent a pardon. the rest of the states have like a series of different ways in which you can get your right to vote back. There are quite a few states where as soon as you get released from prison, like I said, Nevada and Colorado joined those ranks recently, you can vote as soon as you're out of prison. Then there are states where you need to get off of parole or probation. And then there are states that say you have to be both off of parole and probation, complete your sentence, and have paid off all your financial legal obligations that are related to your conviction. And then there are 2 states who do not disenfranchise people on the basis of convictions at all. There are 8 states that have. Yep.
Which states are there?
The 2 states that are Maine and Vermont.
The green ones.
The green ones. Yeah, exactly.
People vote in prison in Vermont, right?
Mm-hmm. So the red states are the states that actually have something built into their election law that says you have to pay off legal financial obligations in order to restore your right to vote. And then the ones that are in orange are Kentucky and Iowa. They both have permanent disenfranchisement, and their rights restoration programs that are discretionary and through the governor both require you to have paid off your fines and fees in order to even apply for a discretionary rights restoration. And then what you see in purple are all the states that require you to either complete parole or probation. Those on their face don't actually mention anything about legal financial obligations, of course, but if you dig into the criminal statutes, what you'll find is that payment of fines and fees and restitution is deeply intertwined with kind of at every level with the criminal justice system, and particularly as conditions of parole and probation. If you don't pay them, you can have your parole and probation extended, and then your right to vote will not be returned to you until later.
I'm just wondering if you can explain why LFO requirements do not violate a poll tax.
I cannot. That's my next slide, actually. Well,
maybe you should first mention where are these fees coming from? What stuff are we talking about?
Exactly. So if any of you do any criminal justice work, I'm sure you've come upon the issue of legal financial obligations and how they can trap people into a cycle of poverty and criminal justice interaction. The types of fines and fees that can be imposed on people because of their convictions are outrageously wide-ranging. So restitution is something you probably are all familiar with. The idea is that you're supposed to pay back, any pay for the harm that you may have caused. If you stole $1,000, your restitution would be $1,000 back to the victim. It's important to remember, though, that restitution actually often includes restitution back to the state, which is kind of a figure of what your crime harmed the state, I suppose, and returning in order to pay restitution to the state. And then there are statutory fines. So often your felony conviction will have by statute a fine assigned to it. And some of those can be mandatory. Some of them are discretionary. And then you have an extraordinary number of just kind of like fees and costs. We really charge people with convictions with the cost of the criminal justice system. So you'll get charged for your public defender often. You'll get charged for the cost of your incarceration. You'll get charged for the cost of your medical care. You'll get charged for the cost of your probation officer. You'll get charged for the cost of your drug testing while you're on parole, and the kind of list goes on and on. And we levy these fines and fees on people who are least able to pay them. People who are incarcerated, people who are coming out of incarceration are disproportionately poor by many standard deviations. They have trouble getting work, and yet they're saddled with an extraordinary amount of debt to the state, and failure to pay that debt can lead to losing your driver's license, which makes it hard to get to work, which leads to more criminal citations when you drive without a license and whatnot. So you can imagine the cycle that folks are stuck in when they're trying to get off of parole or probation so that they can, among other things, get back their right to vote. And I'm going to talk about the legal background, but first I was going to play a short video for you that we put together of our clients in an Alabama case, talking about what the right to vote means to them and the issue of felony disenfranchisement. Yeah, I do not know how to turn it up, but we should. Do you know? Let me check on the slide.
One of the most aggressive
Start
is
over.
Alabama. Almost 200.
Do you guys want me to start it over? Okay. Yeah.
The most heartwarming part was the
Yeah,
beginning.
exactly.
Can everybody hear it now?
Okay. I have to figure out how to do that. But... oh dear. Oh. All right. Hold on. I don't know why I can't see the. Oh no. No, no, no. Oh, well, I don't want to do that. Do you know how I can see? Sorry, we'll restart it somehow. Have you tried this one? I have, but let's try it again.
Just restarts the timer. I wonder if we go
Back. Yeah. That's what I'm hoping. Maybe now. I think there we go.
Not being able to vote and participate in the Democratic side emotionally makes me feel like a ghost. But I don't do.
I work, I pay taxes, I do all the things that everybody else does. But when it comes down to voting, I can't voice my opinion about anything that really matters.
I'm paid by this society, so why can't I have my right back to vote?
6 million people in the United States cannot vote because of a felony conviction. Mostly, they live in 12 states that can take away your voting rights forever. One of the most aggressive is Alabama. Almost 250,000 people have been caught in the net.
The estimates suggest that nearly 30% of the black male population could be barred from voting because of these criminal disputes or convictions.
The Campaign Legal Center decided that a lawsuit was the only way to solve this problem.
All right. So this gets a little bit to the question that was asked earlier. I'm going to spend a few minutes kind of talking about how did we get here? How did we get to a place where over 5 million people have their right to vote taken away? And how did we get to a place where whether or not you can vote depends on how much money you have? And I think the story starts a little bit in 1965 when the Voting Rights Act was passed. The Voting Rights Act, I'm sure all of you are familiar with on some level, was kind of, it was revolutionizing access to the right to vote in the midst of the civil rights movement and kind of the first law that was really able to stem the tide of Jim Crow laws and enfranchise African Americans, particularly in the South. And the Voting Rights Act has a broad provision that bars any discrimination in voting, but it also outlawed a number of kind of particular devices, such as poll taxes and literacy tests and things like that. It did not specifically name felony disenfranchisement as something that was unacceptable. And if it had, we'd be living in a different world today, of course. Felony disenfranchisement has a lot of the same kind of Jim Crow ties that those other laws did, but it wasn't included. And then in 1974, there was a case called Richardson v. Ramirez, which was a case out of California challenging the felony disenfranchisement across the board, saying that this violated the Equal Protection Clause of the 14th Amendment. This was kind of during the heyday of voting rights protections and voting rights and the protections that the Constitution provided under the 14th Amendment for the right to vote. And so I think litigants thought that they might be able to strike the death knell to felony disenfranchisement entirely. And so a case went up to the Supreme Court arguing that all felony disenfranchisement was unconstitutional under the Equal Protection Clause. And what the court decided was that Section 1 of the 14th Amendment, which is where you can find the Equal Protection Clause and the Due Process Clause, can't possibly bar felony disenfranchisement because Section 2 of the 14th Amendment, I can't imagine that you can read that, contemplates the possibility of disenfranchisement for participation in rebellion or other crime. And that language, participation in rebellion or other crime, in the court's opinion, was Section 1 could not prohibit what Section 2 seemed to clearly endorse. And that decision in Richardson v. Ramirez has kind of haunted all felony disenfranchisement litigation since. It has been interpreted not only to kind of allow for felony disenfranchisement ever, but to basically allow it with very little kind of constitutional protection, or at least that's how courts have seen it in recent years. And then you had a series of cases in the early 2000s in which litigators tried to use Section 2 of the Voting Rights Act, which is a ban on discriminatory practices in voting, to say, okay, felony disenfranchisement might be permissible, but it's not permissible when it leads to the kind of discriminatory results that it does in our current criminal justice system. It was a pretty plain textual argument, just apply the test of Section 2 to felony disenfranchisement. It'll either succeed or it won't succeed. But those cases were largely unsuccessful, basically entirely unsuccessful. Johnson v. Governor was a case in the 11th Circuit that held that the Voting Rights Act did not cover felony disenfranchisement. There was a case in the Second Circuit. There was a number of cases that all kind of came to the same conclusion, that it would maybe create constitutional tension with Section 2 of the 14th Amendment if Section 2 of the Voting Rights Act could bar felony disenfranchisement. Justice Sotomayor, when she was sitting on the Second Circuit, I thought wrote a quite excellent dissent in that case, if you're interested in the counter argument. But I won't, delve into that too much. And then there was also a series of cases that challenged this legal financial obligations requirement, saying when you hinge the right to vote on ability to pay off legal debt, that is a poll tax and it is a wealth restriction on voting. There were two cases that were decided by circuit courts, one in the Sixth Circuit and one in the Ninth Circuit, about Arizona and Tennessee, where the court found that basically people with felony convictions don't have any right to vote. They don't have the fundamental right to vote, and so therefore the legal financial obligations restriction would only be subject to rational basis, and it wouldn't get the same kind of protection that poll taxes do, because the poll taxes apply to people who have the fundamental right to vote. There's only two decisions on this issue, though, and I think it's an unresolved question. And particularly in the Ninth Circuit case, there was no allegation that the plaintiffs could not pay. They made it a kind of straight poll tax argument that you can't ever have a poll tax, and that's different than an argument that you're discriminating against indigent folks. And so in Alabama, in our case where we've challenged the legal financial obligations requirement, the district court judge denied the state's motion to dismiss, and distinguished in particular the Ninth Circuit case to say that, the question of indigency is an important question when you're thinking about the 14th Amendment and access to the right to vote for poor people. And so I expect there to be continued litigation on this front, and I expect there to kind of be a continued set of questions that the courts will have to answer about how to grapple with people with past convictions that are being subjected to rules that hinge the right to vote on ability to pay fines and fees. But I want to talk also not only about the legal conundrum that we're all in when it comes to felony disenfranchisement laws, but also just kind of the mess that has been created over the years. So You don't need to be able to read this to understand the problem, which is that this is a flowchart that a colleague of mine made in order to try to map out whether a person in Tennessee with a felony conviction trying to figure out if they can vote or not. And these are all the variations that are possible for determining in Tennessee whether or not you have the right to vote. It depends on what year your felony conviction was, whether or not you were rendered infamous at the time of your conviction, very specific, like what specific felonies you have in specific years, whether or not you've paid your child support, whether or not you've paid your legal financial obligations, and the list goes on. And Tennessee is one of the most egregious examples, but I will tell you that it is very common for states to have laws that are very confusing, and that people with past convictions would need to consult a lawyer in order to figure out if they have the right to vote. And I feel very strongly that we have to get rid of a democratic system in which you might need a lawyer to decide if you have the right to vote. It especially gets really complicated because people move, and so out-of-state convictions and how out-of-state convictions might affect your right to vote when you've moved. People have federal convictions. That's often something that isn't thought of. Nevada, before the passage of this new law, Nevada's Secretary of State had no position on how people with federal convictions could get back their right to vote. There was just nothing in the statutes that talked about it. And there was, in fact, an attorney general opinion that as a result, you needed a presidential pardon. So there was a rights restoration program for people with state convictions and out-of-state convictions, but if you had a federal conviction, you needed a presidential pardon, just because the law didn't account for the fact that people have federal convictions. And so this is the kind of mess that we've created, and that has really not been litigated very much, the kind of ins and outs of the specific requirements, and hasn't been monitored very much as to whether or not those laws are even being followed. So this is why you end up with a system where millions of people don't know if they can vote, right? And even if they know how they can vote, it often requires a great deal of paperwork. You can't just fill out a voter registration form. You often have to prove to the registrars that you've finished your fines and fees, you've finished your sentence, et cetera, and kind of like provide affirmative proof of your eligibility. So you have millions of people who don't know that they can vote, and millions of people who can't quite figure out how to get through the system, even though the legal system does provide them a route to getting back the right to vote. Yes? That's a great question. Yes, I think so.
It's an interesting constitutional question.
Yeah,
right?
I mean,
the federal government could regulate state elections in this.
Yeah, so there's quite a few questions bundled up in there. Let me try to answer. Some of them. With respect to federal elections, I think procedurally they certainly could under the elections clause. So questions about like whether or not you need to prove your eligibility and like provide paperwork and things like that probably could be dealt with. The actual eligibility requirements is a trickier question because states have the right to determine qualifications under the Constitution. I think you'd be then in the territory of deciding whether or not their enforcement powers under the 14th and 15th Amendments would be broad enough under the standard that the court applies to determining whether or not a federal statute that tried to go beyond that was justified by their enforcement powers under the 14th and 15th Amendment. So I think is that a close enough answer?
Yeah, that's about as good as you're going to be able to do. It's one of those cases that could go either way, I think.
Yeah, I mean, and I think it would depend a great deal on what the record was in in Congress as to the impact of these laws, et cetera. Which
it might depend on who's on the Supreme Court too.
Yeah. Everything depends on who's on the Supreme Court. So you can imagine how intimidating this can be, and I will tell you that one other thing that really concerns me about this kind of maze of requirements is that the result is that a lot of groups that do voter registration work don't really work with people with convictions. They knock on the door and somebody has a past conviction, doesn't know if they're eligible. They don't have the training or legal expertise, and so they pass them over. And so you end up with a kind of self-reinforcing marginalization of these communities. And one of the things that CLC is doing is trying to like provide that backup to groups that do voter registration work so that they don't have to do that anymore. It's certainly not for lack of want of these groups to help people register to vote. They just don't have the kind of resources to spend the kind of time you need to help people with convictions in certain states.
What's the process of actually determining? So if you kind of go through this flow chart and you determine, yeah, I think I can, and you go to register, is there some kind of office that says, no, you can't because of this? Like, could they just apply anyway and let the office determine?
That's a great question. So a couple of problems. One, every voter registration form requires you to sign under penalty of perjury that you are eligible to vote. And so you need to be pretty sure that you're eligible to vote. Now, of course, if you make an honest mistake, you shouldn't be prosecuted for that because perjury usually requires some sort of CINTA requirement. But that does, of course, folks feel afraid, and of course, if people don't know, they shouldn't be signing under penalty of perjury that they do know that they're eligible to vote. And so it leaves folks in this really difficult kind of gray area. The other question about administration is my next slide, which is that in theory, the states should all have systems set up that would be able to check on the back end with state felony records to determine if someone is eligible to vote. The Help America Vote Act suggests that they have to have those types of systems where they share data internally in order to be able to determine if someone's eligible to vote. I think that's in recognition of the fact that it would be hard for folks to all totally self-regulate, and that if you want to have only eligible voters on the rolls, you should make sure that you have a good system. As a practical matter, I have found that these systems are completely broken. They often only work in one direction, which is that states get the data they need to take people off the rolls when they get felony convictions, but they don't collect the data about whose rights have been restored. And so people whose rights have been restored will apply to register to vote, knowing that they are eligible, and they will get a notice in the mail that says, our records say you have a felony conviction, so you're not eligible. And then it's on them to provide the proof that their rights have been restored. So states have managed to get the records about who should get taken off the rolls, but not about who should be allowed back on. Now, of course, I'm wildly generalizing. Every state is specific, but I have seen that repeatedly. And I just took a picture of a newspaper article from the Des Moines Register that there was recently some research done into Iowa's system in which, even their system of who has felony convictions was wildly overbroad. It was sweeping in people who've been charged with felonies but not actually convicted of felonies. It was sweeping in people who'd had their felonies expunged or deferred so that they shouldn't be on their record at all. So they didn't even they had a wildly overbroad system for pulling in who should be taken off the rolls. And then you had folks who did not have felony convictions that had to kind of fight to get themselves back on the rolls. And these are the types of problems that we see every day now that we're running this Restore Your Vote program. But all is not lost. So, the first part of my presentation is pretty doom and gloom, right? Everything's broken. Millions of people can't vote. Even more millions of people think they can't vote. It's impossible to figure out and whatnot. The good news is that all of those problems mean that there's a lot of work to do, and I think a lot of kind of low-hanging fruit work to do, right? There's a lot of kind of administrative issues to clear up that would actually make a difference in hundreds of thousands, if not millions of people's right to vote. And we have a big moment for change available because public opinion is overwhelmingly on our side on this issue. The American people believe in second chances. They believe that the polling is not good on Americans' feelings about voting in prison. But once you've served your time in prison, Americans believe that you should have the same right to vote that they do. And Desmond Meade obviously is he's changed the landscape with his work in Florida. He led the campaign in Florida for Amendment 4, and he was one of Time's most influential people in the world, and rightfully so, because he changed the idea of where this work can be done. I think there was a sense that Florida was hopeless and that this was not going to work, and he did not have a ton of support or monetary support when he started this campaign, but he was insistent that he had a vision and a message that would resonate, and he was absolutely right. Amendment 4 passed with over 70% of the vote, right? And so I think that there are opportunities for this everywhere. And if you remember looking at that map, it's not as though the work is only in hard states. There's really important work to do in Colorado. In Connecticut, there was just a bill that passed the House and then died in the Senate that would have restored the right to vote for people on parole, and would have also removed a fines and fees requirement. I was really hopeful that was going to pass. It did not, but that should pass. That should change. There's a lot of work to be done in places where I don't think it's as uphill a battle as you might think. And even in places like Florida, there's a lot of opportunity. Iowa is now in the midst of trying to change its law and provide for rights restoration, and the governor supports it. So this is not the type of issue that you can only do in blue states, but there is a lot of work to be done almost everywhere. So, one of the ways you can work on this issue is just to get out there and work on the politics. There are campaigns that are starting up in Kentucky, in Iowa, and I guarantee you where most of you live, there's some work to do. Yeah.
So a felon can usually also prevent you from being barred. Is there work that we can do in our communities so that people who are affected can also advocate for themselves?
Yeah. That's a little... Yes, the question was that the felony convictions can sometimes stop people from becoming lawyers and becoming barred because of the character and fitness requirements in the bar. And the question is there work to be done around that issue? I think the answer is yes, but I don't actually have a ton of expertise in it. I mean, I know I've read articles about individuals with past convictions doing really extraordinary work to advocate for themselves and get ethics boards to overturn their decisions. And I think that they really deserve the support of the legal community when they do that, and I think there has been some success in that area, but I'm certainly not an expert in it, but I do think that they deserve the support of the legal community. Sean Hopwood at Georgetown Law, he's
Remarkable
a professor
story.
of law now, and we need more people like him that have that kind of experience in the legal community.
Right. And it's sort of outside our scope of our work, since we're about voting. But
yeah, but as a lawyer, I very much support it. And then the other area of the law, the other area of work that I think that everyone in this room can do in their home states is work about education and outreach, right? So when we recognize this problem that people are not going to be able to figure out whether or not they can vote or not, we kind of took to the internet to see if there were easily available tools, and there really were not. It was a very confusing mess of information out there about whether or not you can vote. And so we created this tool called restoreyourvote.org that has all 50 states and DC, where you can kind of plug, as you can see, you can pick your state. So I picked Pennsylvania, and then you answer a series of questions based on your state. We don't collect any information. It's entirely anonymous. It doesn't stay in our system. And it'll tell you either, yes, you can vote, and here's the link to your voter registration site, or it'll say, no, you can't vote, but here's when you will be eligible to vote, or yes, you can apply to restore your right to vote, and here's how you do that, and here's where the paperwork is, and whatnot. And we've paired that with a phone number and a email so that when people feel caught up or still confused or they want extra assurance, we can provide it for them. Yeah.
Has any work been done with departments of correction to provide information to inmates as they're about to leave?
Yes.
Can you repeat that question too?
Yeah, so the question was whether or not there's been any work done with Department of Corrections, because in order to use them as a tool for education and outreach? And the answer is yes. There are a number of states that actually require some form of notice as you're outgoing from the Department of Corrections. And that's a great practice that, again, is another kind of smaller incremental change that you can push for that would make a really big difference. There's actually really interesting research that it really, the kind of notice matters a lot. If you just put the notice in with folks' exit packets, there's so much they're getting at that moment that they don't really notice. But if you send out a mailer later, a month later or so, that's specifically just about voting, folks are much more likely to notice it. The other thing is, even if your state doesn't have a law or you're not in the place to get, advocacy to get a law in place, I know a lot of advocates that just have worked directly with the jails in their community, with the Department of Corrections in their community, and gotten them to voluntarily agree to include information about the right to vote in the materials that they provide to people as they're leaving the system. And it's a really important part, I think, of how to get the word out. So we created this tool so that people with convictions can use it, and we push it out through social media ads that have reached over 50,000 people, and that's great. But we also want it to be a tool for advocates, so that when folks are out in the community, they're doing ordinary voter registration work or specifically focused on this issue, they're able to use this tool to do so. And so, I would encourage you all to think about ways in which you could maybe fold this work into other voter civic participation work that you do. Yes?
Sure, use the mic, Jack.
I really hate to change the subject, but I've been waiting an hour to hear about the Voting Rights Act. I wonder if you want to talk about it, or maybe there's some reason you don't want to talk about it. But going back to the felons a minute, I'm just wondering whether the argument for prisoners doesn't help to defeat politically what you're doing. Okay, it overstates and excites. I would think it would excite a lot of opposition.
Yeah, I'm happy to answer that question. I also want to know, what specifically about the Voting Rights Act do you want to hear? So we can do it. What specifically about the Voting Rights Act would you like to hear about?
Well, getting it back.
Oh, that's not the subject of this panel, but I'd be happy. Maybe at the end we can talk about how to get it back. Yes.
Yes. Derek Al from Georgia. The past gubernatorial election, I was doing election day work, and in the call center we had a issue with someone who said his rights were restored. He was registered to vote at a train station by an election group. And he went to the precinct to vote where he previously lived, and they said, "You're not on the rolls, you can't vote." And he says, "Well, my rights have been restored," and they refused to give him a provisional ballot, and was told then to go back, and you have to go back and get proof that your rights have been restored, and then go back down to the Board of Elections and show your proof. We had a little stalemate. I don't recall what happened in that situation, but what are you telling people with respect to the actual trying to exercise their right to vote after the rights have been restored and proof and provisional ballots and all of that?
Yeah, it's a great question. So I'm going to try to answer these two questions in a row, and Paul, let me know if you have any additional words on it. I think on the political question, I think it's a very good point. There's so much work to be done that Americans support overwhelmingly on the post-incarceration front, that by moving the national discussion to incarceration, we really risk a political backlash. I think it's a really good point. I'm not a political strategist, and so it's a little bit outside of my area of expertise, but I do think it's an important question, one worth thinking about. I also think that these campaigns are most successful when they're done on a state level, because the laws are also different and the political energy is very different. So, it's one thing for DC to be focused on incarceration issues, because DC is already allows people out of jail to vote. It's another to bring it to a national stage where there's still a lot of work to be done outside of pushing all the way to prison. On the question about the provisional ballots, it's heartbreaking to me that I think that that's extraordinarily common. And that's why I do think that, you know, if I could stress something that lawyers and student lawyers can do is focus on making sure that your state actually has a system that works for people with past convictions. You know, like I said, the vast majority of people with past convictions have the right to vote. So this is an easy battle, or at least it's a winning battle to make sure that they set up systems that work for people. And it's far too often the case that things like that happen to voters, and we just need to raise hell about it because we're on the winning side of that argument legally. There's no question about it. These people have the right to vote, and but there needs to be watchdogs, and there need to be watchdogs everywhere, and it's hard and complicated, but it's something that we can do on a really individualized level. And if you raise it 10 times in a state, they're going to start fixing the system.
Secretary of State didn't want to vote anyway, so that's why they have the system.
I don't disagree. Yeah, Secretary Kemp, yeah.
Yes.
Yes.
Let me ask this question. How far back historically has felony disenfranchisement existed, and is it related to civil death?
I think so. My understanding is that the kind of concept of felony disenfranchisement does kind of date all the way back to civil death. So for those of you who don't know, there used to be kind of this idea that the form of punishment, like, I mean, this goes back really far, and I'm not a historian, but you know, that the way that you'd be punished is basically to be treated as an outcast, and you would no longer be considered a citizen, basically. You would lose all your rights, and you just wouldn't be recognized for anything, and that would be your punishment. And obviously part of that is that you couldn't participate in whatever political system they had as part of civil death. And so felony disenfranchisement goes back really far. In general, in America, it started in Kentucky when that state's constitution was ratified in 1792, was the first state to introduce felony disenfranchisement, so it's old. That being said, the felony disenfranchisement provisions in the United States were pretty, limited in their scope up until the Jim Crow era. They often, for example, in Alabama, the felony disenfranchisement law was only for bribery, perjury, corruption in office, a few kind of limited political crimes you would lose your right to vote, but it wasn't kind of broad-based, every criminal conviction led to the loss of the right to vote. And then in the Jim Crow era, we saw an enormous expansion of these laws to no longer be kind of targeted at political crimes or whatnot. They were targeting black people instead. And so we saw a huge kind of increase in what the scope of felony disenfranchisement laws. So the answer is the concept is very, very old, but the current system is relatively new.
Keep going.
Yeah. So I talked a little bit about the tool, and I think the tool is very helpful, and anything you can do to help push it out to your communities, I think would make a great deal of difference. But for the reasons, questions such as, I'm sorry, what was your name?
Derek Alfred.
Derek asked is, these folks really need individualized attention if we're going to fix the problems. We need individuals to apply to register to vote, and then we identify, and then those people apply, and then we are able to follow up with them and figure out what the problems are, and then push the administrators until the problems are fixed and until you're really satisfied that the problems are fixed. And so we've been trying to do that ourselves on the ground with organizers. In 2018, we had organizers on the ground in Alabama, Nevada, Arizona, and Texas, and this is our organizers and some volunteers running a workshop to help people with past convictions. This is something that can be done in almost every state, right? Whether it's kind of canvassing to make sure people know that they have the right to vote in states where it's pretty easy, Pennsylvania, post-incarceration, you can vote, up to places in Arizona where it's going to be much more complicated. It depends on how many convictions you have and whether or not you've paid off your fines and fees and whatnot. And then you can help people, apply for fee waivers. You can help people kind of get through the various systems. They can apply for clemency, et cetera. There are lots and lots of ways to do this on an individual level that then will build power for change, I think. And then Another big benefit of doing this individual work is you can tell stories, right? So I have 2 articles that we were able to place about 2 individuals. One is in Vox and one's in the Tampa Bay Times, about people with past convictions talking about their personal experience. And in this time where there is ripe energy for potential change, telling stories is an important way of getting there. People are extraordinarily sympathetic to folks talking about how demoralizing and dehumanizing it is to deny people the right to vote, and how important it is to their dignity when their right to vote is restored. And then I just wanted to give you an example of how small administrative advocacy can make a big difference. CLC did a survey of all the voter registration forms in all 50 states and found that tons of them just had inaccurate information about who could vote for past convictions. Either inaccurate or just totally insufficient information, like, I do not have a disqualifying felony or my rights have been restored, when in fact the case is that post-incarceration everyone's rights are restored. That would be an easier way to say it, right? And we were able to get tons of states to change their forms. Just say, hey, your forms are wrong. It violates the NVRA for your forms to be wrong, but also it's just the right thing to do.
You have to be willing to threaten to sue them.
Sometimes you have to be willing to threaten to sue them, but there were states like Delaware, just nobody had paid attention. The law had changed for the better, and nobody had followed up to make sure the forms got changed. As soon as I spoke to the election commissioner, she, made all sorts of changes right away. Not all of this is kind of nefarious, although some of it certainly is. And we're fighting with both the state of Tennessee and Alabama right now about changing their forms and making them more user-friendly. But this is the kind of small administrative advocacy that's really important. Go to your county registrars and make sure they're giving the right information to people with past convictions, because a lot of them aren't, and a lot of them don't mean any harm by it. They just think that the rules are something different than they are, and the only way to change that is kind of, individualized work. So there's a lot to do. And I think there's a lot that all of you in this room could do on this issue. We can talk. So I'm going to open it up for questions. How much time do we have left?
About 10 minutes.
10 minutes.
Breakout session.
Yeah, we have about 10 minutes left. Paul, do you want to talk about how we can get back the Voting Rights Act really quickly? That's a quick question, right?
This is Section 5 of the Voting Rights Act you're asking about, which Shelby County decision nullified by saying there's no covered states. Well, there's actually a bill that's in the House. If the Congress wants to fix it, they can fix it. That's the way to fix it, right? So
yeah.
We just need a different Senate.
Yeah.
Well, that too.
I think there's likely to be hearings later this year on the Advancement Act in the House. I think they're scheduled for November or so. So we need to focus on building a really good record.
This is a 2021 at the earliest problem.
It's true, but we can start building the record in the Congress now. Go ahead.
Hello. So are there resources for, or is there an opportunity for some model policies or model statutes that advocates can kind of grab and bring to different states?
That's a great question. I am not aware of anyone who's disseminating kind of model legislation on this issue, but it is a thing that we've thought about. Creating, but CLC would certainly be happy to advise on kind of where there are good states that have good models, right?
One of the things we do is field calls from people all over the country who are trying to fix their local and state election laws in lots of ways, and we have people whose job it is to sort of give advice, because it's hard to do something in the context of any given state election code that's cookie cutter. But the basic thing that, if you want to keep it simple, the easy way to fix this is to do what Nevada just did, which is to say, if you're no longer behind bars, you should be able to vote.
Yeah, and pair that with
a very simple rule.
You have to tell people on their way out and give them a voter registration form, and you're in a really good spot. So that's certainly our kind of number one advocacy suggestion, but there are lots of ways to make incremental changes, and CLC's, our work is focused on being able to provide those tailored solutions, and then rely on amazing advocates like all of you to try to push them out in your communities.
I was wondering if you could comment on a different issue, but related, about pretrial detainees and litigation around practical
You know something about
disenfranchisement
that?
there and opportunities for direct services to help with that.
Yeah. I would love to talk about that. I just got back from Ohio taking depositions on a case about pretrial detention and access to the right to vote. So this is an issue that's fresh in my mind. For those of you who are less familiar with it, there's about 750,000 people in the United States who are in pretrial detention on any given day in jails, which means that there's about 750,000 people who are likely eligible to vote on election day that are behind bars. As you can imagine, there aren't a lot of good practices about making sure that people in jails get their ballots. A lot of states do have rules that say, you know, you can get an absentee ballot, but the practicalities of that are often not worked out. In deposition testimony recently, we just got out, it can take, it can take a week for you to get commissary, to get a pen and a envelope and a stamp, and then you have to send it out, and you have to know who to send it to, and then send it back and whatnot if the jails haven't set up a more user-friendly system. And then for a lot of folks who get arrested, our case in Ohio is specifically about people who get arrested in the days leading up to the election, right? They are often arrested after the absentee ballot deadline, and so they're just completely out of luck. We represent two individuals who were arrested on Friday night and Saturday morning, and so it was past the voter registration or the absentee ballot deadline in Ohio, and they just would have no option to vote whatsoever. And we sued, and we actually obtained a TRO for them to vote on election day. They brought them their ballots, but we brought it as a class action to hopefully get long-term relief for all of these people. It's an enormous issue that is, I think, a problem in all 50 states, and it requires a great deal of kind of close coordination with public defenders and others who work in the criminal justice system to find folks who can bring these types of cases and assert their rights and try to force the states to change their practices. And so I think there's a lot of work to be done at your local jail.
Yeah, it was tricky with this Ohio case because the people had to have been arrested and put in jail in the last 2 days. We had to find them and get the TRO done by Tuesday. You know, it was really remarkable, but it got done.
Yeah, but I think there's tons of work. I know lots of advocates that just go and bring voter registration applications and absentee ballot applications to their local jails, and all of that stuff makes a big difference because the jails just aren't doing this work themselves for the most part.
It's fair to say a lot of states have provisions for people that are in the hospital because they've had an accident or illness, but they don't have parallel provisions for people who find themselves in jail.
Yeah, and that's the case in Ohio. They'll bring you a ballot and you're in the hospital through election day, but they won't do it in jails.
Shelby?
This question kind of arose in my mind as you were answering that last question. And this might be getting way ahead of the skis here, but for states that are interested in complete felon enfranchisement, like Maine and Vermont, is it... I understand that there are a lot of problems around, so if you are transported out of your county to go to a jail somewhere else in the state, we talked about this in class, Professor, and kind of what you all recommend is the process for, are they voting absentee for where they came from, or are they voting in the district that they are in prison?
So it's our position that just like everybody else, people get to decide what their residence is. And so there's going to be some folks that when they were picked up are homeless and the prison is the only residence they have. And in that case, they should vote in the district of their prison. But most people don't consider prison to be their address or their residence. It's a place that they are being forcibly held. And most of them would like to vote in their home communities, and they should be able to do that.
This is parallel to the issue that arises with respect to the census and where you count people, which is a big hot issue these days.
Exactly. And so what Nevada actually passed an anti-prison gerrymandering law this year as well, and that's what they're doing, is that most people will just get counted in their home communities, but if somebody doesn't have a home community, they get counted in the prison so that everybody gets counted.
Hi. I just wanted to ask kind of a more general question about online voting. I know that's a lot of people at my age want to do that. They want to stay home and vote through the internet, and I just want to know about the merits, the pros, cons that you all have seen with that.
I
Terrible
really
idea.
don't know a lot about it, but it's a bad idea because there's no paper trail, there's no kind of ways to audit it. There's just so much security risk.
Actually, the technology of voting is moving in the opposite direction. People in Oregon are using the U.S. mail and paper ballots, and the vulnerability of the internet is such that I think people are pretty skeptical of where we're going to get there anytime soon. I mean, it makes obvious sense. You vote, and there's lots of other important things you do, like access your bank accounts and stuff. So you would think it could be done, but at the moment, I would say we're not going there.
Yeah.
Generally, I think there are a few places that are trying it, but it's a pretty risky thing. Yeah.
So I want to put a really quick plug for the bill that was just introduced in D.C. with all of the council members co-sponsoring it to enfranchise those who are incarcerated. A lot of the issues that we've discussed here today are going to be issues to grapple with there, so it could use any advocates on the ground who live in the district. A quick question about where executive branch officials could make a difference in these different states. I know, for example, Iowa in its history had dueling executive orders from Democratic and Republican governors. Of course, Terry McAuliffe was famous for what he did in Virginia. In Georgia, there's a weird provision about felonies involving moral turpitude and the way that the executive branch and the Secretary of State has interpreted that. So I'm wondering if you could talk about opportunities there.
Yeah, I had that in my outline and didn't get to it, so thank you. One of the many reasons why advocacy is very available to you all in the states is because you don't have to necessarily go through the legislature to fix some of these problems. A lot of it can be done by executive action as at least a stopgap if your legislature is not likely to move on these issues. There are issues around like how broadly executives can do it. In Virginia, when Terry McAuliffe tried to announce that everybody would have the right to vote back, blanketly, that he was sued for that, and he lost in Virginia Supreme Court. But certainly, governors have broad discretion to enfranchise folks, to create kind of streamlined processes for enfranchising folks. At New York, Andrew Cuomo has taken executive action to enfranchise people on parole. And so there is really important advocacy work that can be done at the executive level because they can basically undo most felony disenfranchisement with a stroke of their pen, at least for individuals. Of course, the big problem with that is that then another administration can change it more easily than changes in legislation, and that's where you end up with states with these really complicated systems now, where if you were convicted before 2005, you have the right because some governor restored your right to vote, but afterwards you don't or whatnot. So it's always better to get legislation if you can, but there's lots of opportunities with governors. And then secretaries of state, of course, always have rulemaking authority when it comes to kind of things around the edges, especially process issues and interpretation issues. So that's a place where you can do administrative work too.
We're getting the stop sign
Yes,
here.
I'm getting the stop sign. All right.
All right, so we're going to break out into groups shortly. As we mentioned in the beginning, there will be a group for folks who are interested in CITC. There will be a group to talk about canceling classes at your law schools, and there will be a group to continue this conversation and figure out more about how you can help be an advocate with Danielle and Paul about what they're doing on voter restoration rights. Before we break out and before we thank our amazing panelists, I also want to reiterate that all of these are intertwined and very much crossover. Part of the reason for canceling classes on Election Day is so that people can get out on Election Day and make sure people are exercising their right to vote. They have the ability to do so. Danielle and Paul may or may not have ways that you can help on Election Day. And same with Constitution in the classroom. It's incredibly important to get information out to students, especially in high schools, but elementary school and middle school also, about why voting is important, who can vote and who can't. There are so many stories about people who have the easiest time in the world voting and don't understand why this is so hard for so many people. So just understand that all of this is intertwined. There will be plenty of opportunities throughout the next couple of years as we get closer to 2020 to reach out to ACS, reach out to CLC, figure out how you can get involved in different capacities.